Good evening. Welcome to Lawyers on the Line. I'm Jim Peterson, a partner with the Falsani, Balmer, Peterson, and Balmer law firm, and this evening's moderator. Tonight's topic is bodily injury claims, motor vehicles, and animals. Well, we may skip a little bit over the animal part. Motor vehicle crashes remain a leading cause of injury and death in our society. Highway traffic deaths rose in Minnesota last year from 2017, reversing a downward trend that began in 2015. Thousands more are injured in motor vehicle crashes, some by animals in the roadway. Recently, Governor Walz signed a law banning hands-on cell phone use while driving. We'll talk about that. Tonight's panel, Bob Falsani from the Falsani Balmer firm, Jim Balmer from the Falsani Balmer firm, and Mike Kreidler, a partner with the Stitch Angel Law Firm out of Minneapolis. Our panel, unfortunately, a bunch of old white guys, unfortunately, will respond to your questions about bodily injury claims. Please call us with your questions at 218-788-2844 or 1-877-307-8762. So let's start with a couple of the animal-related questions. Bob, I have a question for you, and this is a case that I had a few years ago. So we'll quiz you on the result. Person riding a bike, okay? Riding a bike on a normal street. Dog suddenly runs out. We don't know what the intent of the dog was, but the bike rider, startled, falls off the bike, suffers an injury. Is the dog owner liable for that?
Yeah, I think the statute covers that kind of activity. So I had one where the dog knocked the guy off his motorbike, and he got creamed, of course, and we recovered in that.
What if we don't know what the dog's doing? It didn't knock the guy off the bike. It just was there, startling.
It might get a little iffy, you know. I mean, you have to develop some causal link between whether you really fell off because you were threatened by the dog somehow.
All right.
Well, I don't think that you have to prove that the dog had any specific intent in order to recover. You just have to be able to show what Bob mentioned, which is that the dog's actions caused the injury in some manner. It doesn't necessarily have to be a bite.
Right, and you don't need a dog psychologist to prove the dog's intent.
Exactly, although I know somebody who used a dog psychologist for their dog to go through rehab after being injured.
Well, does it matter, Mike? I'll direct this to you.
Was the psychologist treated the dog or the person?
That's a good question. I don't know. Dog trainers actually train the owner, not the dog. So
I've heard of dog chiropractors.
Yeah.
Anyway, Mike, let's change the question a little bit. Does it matter where this happens? Because where I live, there's no leash law, but in the city, of course, there is. Does that matter?
There's a state statute that imposes a strict liability when a dog injures somebody. It doesn't matter where it happens, whether it's in the city or in the country.
Yeah, years ago, they used to have the rural exception.
Yes.
When we were young. Remember?
Well, my memory doesn't go back that far.
Well, and before that, there was every dog was entitled to one bite, which meant that you couldn't sue the dog owner unless the dog owner had knowledge of the dog's dangerous propensity. So the statute was passed, and the statute's called the First Bite Statute, and that controls in Minnesota, and there's a similar law in Wisconsin.
Yeah, but in Wisconsin, if there was a prior bite,
you get punitive damages.
I think you get double damages.
Oh, okay.
Speaking of which, I'll leave this open to whoever knows. What if similar situation, except you're driving your car, and all of a sudden a horse runs out in front of you, and you hit the horse and suffer injuries?
Well, I believe that you have to be able to show that the owner did not take reasonable precautions to confine the horse. And if you can show that, then the owner of the horse is legally responsible for the harm caused by the horse.
Yeah, that's that cow horse
Right.
thing where you're supposed to have fencing for your animal.
I actually had a case recently in southeastern Minnesota similar to that, and I believe that you properly described what the law is.
Oh, great.
Yes.
I
agree with you.
I won that
we don't
case
do that
too.
to
And
them.
they kept saying how wonderful the fence was, and of course all this testimony was
Right.
the horse kept getting out all the time. So.
But do you get multiplied damages if you can prove that the negligent fencing or whatever, the enclosure?
Yeah, there is a special statute.
I think
on
you got
that.
triple damages for that.
Right. Yes, but that's very hard to get the judge to go along with that. So.
All right.
Yeah.
So here's another question involving dogs. And the setup is one of our favorite movies, one of the Pink Panther movies. Okay? Clouseau walks into a hotel. Okay? And there's a desk clerk there with a little dog. And he goes, "Does your dog bet?" And the desk clerk says, "No." So he reaches down to pet the dog, and the dog bites him. He said, "I thought you said your dog did not bet." He goes, "That is not my dog."
Monsieur.
Okay. Yeah, monsieur.
You must have worked
So,
on that all weekend.
I
huh?
totally did. Okay, so question is the hotel or the desk clerk liable anyway?
If they're harboring,
If it's in Minnesota, isn't there a recent case?
well, it's the harboring.
Right.
Yeah.
Yeah.
So if you happen to have if your daughter drops off her vicious dog for the weekend and the dog bites somebody, then you're liable too.
Right. So Blake Edwards may be wrong on the law if it's in Minnesota.
Yes.
All right. Let's move on from animals.
All right. How about this one? What if a deer runs out in front of your car and you hit it and you get hurt?
Go ahead, answer your own question.
All right. In Wisconsin, you've got a problem. But if your car is principally garaged in Minnesota, you can get your auto insured to take care of your medical bills up to $20,000 because Minnesota is a no-fault law state. And your medical bills and wage loss are paid in Minnesota regardless of fault and regardless of cause.
You might get med pay in Wisconsin, wouldn't you, for that?
Yeah, that's true. If you have med pay features on your policy, you can get that covered up to the extent of the medical payments coverage on your policy in Wisconsin. And if you can show, if you're a passenger in the car and you could show that the driver of the car was negligent in failing to avoid the deer, then you could sue the driver of the car and get compensated by the auto policy covering the car.
Mike,
In both states.
Mike does a lot of defense work and has for years, but have you ever defended a case where the guy's driving along and there's a bunch of deer and they don't slow
I
down?
have not.
No. So it's the case where, they're driving, everybody knows
unusual.
if you see the
Right.
first deer, there's probably somebody more
Right.
else around. So I've had that case where
Right.
the guy sees the first deer, instead of slowing down or anything, he keeps going, and then he hits the third
Right.
deer, and then we have a lawsuit over that. So
Yeah,
'cause I have the passenger,
Yeah, I had a case similar to that too. So.
Mike, this whole no-fault issue brings up a question that we get all the time, which is, why in the world does my insurance company have to pay my wage loss and medical bills when it was 100% the other guy's fault? And you must hear it a little bit on the other end.
Well,
But-
it's because the no-fault statute is premised on, the premise of it is that nobody's at fault. But if you're entitled to no-fault benefits if you're involved in an automobile accident. And the no-fault benefits, I think Jim already alluded to, they cover your medical expenses up to $20,000, and they cover any wage loss that you may have sustained up to $20,000. And it doesn't matter who was at fault. The only the triggering event is that those damages arise out of the operation, out of an accident involving a motor vehicle.
Yeah, when they passed the no-fault law in 1973, and it was 75, I guess it was.
Became
Yeah.
effective
I
75.
think it was, maybe it was 20,000 then, or maybe it was 10 for the medical, but whatever, it hasn't been adjusted for inflation. So 20,000 for medical now goes away in a hurry. And then the wage hasn't really been adjusted much. They increased the weekly to 500 from 250, but again, as time has passed, that's not very effective either. So there's some real question whether the no-fault law has outlived its usefulness. Either that, or they'd have to jack the amounts up way high, and then that would cost everybody a lot of money for that kind of the part of the policy. So I don't know.
The benefit, as I understand the rationale behind the law, is you don't have to sue someone for causing the accident just to get your bills paid, at least initially.
Yeah.
Right.
Right.
So beyond the no-fault part of it, when can you actually sue somebody for causing the damage in the first place?
Well, when you breach a no-fault threshold, and the thresholds are fairly easy to get to, $4,000 worth of non-testing medical and 60 days of disability, it's usually missing work, and permanent injury or a permanent aggravation of a pre-existing condition, or just disfigurement, and that doesn't take much, you know. So in a lot of cases you find one of the thresholds has been breached, so that you still can have a claim for your pain and suffering. But again, I think the law is really an outmoded law right now. And
But-
some of the states that originally passed it have gotten rid of it.
But it's any one of those
Yeah.
conditions being met. You don't have to meet all of them.
No, that's right.
Okay.
Yeah.
And Wisconsin does not have a no-fault threshold requirement. It's actually easier to bring a legal action for injury in a motor vehicle collision in Wisconsin than it is in Minnesota. And it's easier to make a larger recovery for your injuries in Wisconsin than it is to make a recovery in Minnesota because of some other laws. I don't know if we'll get into those or not, but
Do you
Mike-
agree with that, Mike?
Well, I don't know if I necessarily agree with the statement that you can get more money in Wisconsin for the same case, but,
collateral source rule.
okay, yeah,
They don't.
okay.
They have a wide open collateral source rule, unlike Minnesota.
all right. Well, that could have an impact
there's-
undoubtedly in,
Yeah,
But
there's a-
you know, but if you're in one of those rural Wisconsin counties versus the Twin Cities,
right,
that's a little different story in terms of damages, don't you
that's
think?
true in either state, though.
yeah.
Yeah.
So
So, Mike, once you get to the point where you can make a claim for pain and suffering, wherever you've got your lawsuit, how do you determine what dollar amount corresponds to what pain and suffering? Is there a way to do that?
Well, if somebody that handles these kind of cases has you develop a sense of what these cases are worth over time. But ultimately, if the parties can't agree as to what the pain and suffering damages are worth, that issue is submitted to a jury, and the jury decides that. And the judge presiding over the trial will submit to the jury factors that the jury can take into consideration in determining what the damages are worth. But ultimately, it's up to the jury.
And
Pain
you're-
and suffering is sort of code, though. I mean, it really is the human loss that somebody suffers, and you know, just saying, "Well, I had some pain and I had some suffering," you know, that doesn't really. People don't understand what that is. So it's, you know, I had some pain and suffering because I couldn't sleep through the night, and I was waking up in the night for 20 months in a row, or I couldn't walk my dog, or I couldn't play with my children, and every time I lifted my little 3-year-old, my back was killing me. That's pain and suffering.
Right.
really an impact on the quality of life the person had before the crash.
Or if you had a broken bone as a result of the accident and they fixed it, but it's not the same as it was before the accident, that's worth some money. The question is, what is it worth? And that ultimately is, if you're dealing, the insurance companies, they process a lot of these kind of cases. Jim and Bob handle a lot of these kind of cases, so you develop a sense as to what these cases are worth over time. But it's ultimately, if the parties can't decide, the plaintiff and the defendant can't decide what to settle a case for, then the jury ultimately has to make that decision.
Now,
And that's
Mike,
the way the process works.
Mike does quite a bit of mediation now, and
Yes.
later in his career here. What do you find insurance companies tend to accept in terms of non-economic damages for pain and suffering and human loss? What kind of strikes their heartstrings if they have?
Well,
it?
I think it depends on what kind of physical injuries the party sustained, and what the doctors say about the injury, and because typically in a personal injury case, the plaintiff, the treating physician will testify with respect to the nature and extent of the injury and what kind of pain and suffering it might cause, and then of course the other side typically will have what's called an independent medical evaluation done, where they hire a doctor who will, address those same subjects. They don't always agree. And so it's ultimately, the insurance company takes that all into consideration. And then the insurance company is going to take into consideration as well what kind of a witness they anticipate the injured party or the plaintiff is going to make at the time of trial, what kind of a witness their insured is going to make, and all of these different factors. So you can't. A lot of it's based on the experience of the lawyer representing the plaintiff and the defense lawyer and the insurance company adjuster.
You mean in terms of
As far as
evaluating a
evaluating the case and reaching an agreement, and of
Right.
course, as you well know, the greatest percentage of cases get settled before they go to trial. But you still try cases, and then those cases that get tried, they also have an impact upon how future cases are going to be evaluated by the parties.
Now, Jim and I think that the nature of the plaintiff makes a big difference in cases.
I agree completely.
Yeah.
I agree completely. And if you have a plaintiff that seems to be honest and forthright and makes a good impression as a witness, you're going to get more money for your case. If you have a plaintiff that isn't a good it doesn't come across as a good witness and perhaps has been involved in other lawsuits or, had similar cases in the past, that has an impact on the value of the case.
I think that the audience ought to understand that in Minnesota, this mediation, which is a form of alternative dispute resolution, alternative to a jury trial, is required in all Minnesota courts.
Right.
Whereas it's not necessarily required in Wisconsin, but usually ordered by the judge.
Right.
So,
Yep.
and now most cases settle at mediation.
We did get a couple of questions from callers. Thank you. This is a pretty easy one. Bob, does it do any good to put up a beware of dog sign?
Yeah, that makes you really liable then, because you know that Rover's not the nice dog.
Well, it might prevent the bite in the first place, but if there's a bite, it doesn't help you.
I mean, I've had last 4 or 5 years, I mean, the worst dog bite cases with the most vicious dogs. I mean, they've got these signs up, and then the dog jumps over a 6-foot fence and attacks the little old lady. I mean, it's great, Then you have a picture of the beware of the dog sign. Oh, boy.
Okay, simple question. How long do you have before you have to bring a lawsuit for a dog bite injury?
I think it's 6 years.
6 years.
6
Yep,
years.
they're right. I
Okay.
was thinking because it's different in Wisconsin. It's 3 years or 2 years. I'm not sure.
Let's talk a little bit about one of the things that listed in the intro, which is the new hands-free phone law that's coming into effect in Minnesota in a couple months. What effect is that going to have on car accident cases where somebody's using a phone at the time of the crash, Mike?
Well, I think you can still factor that in if somebody's using the phone. Quite frankly, I think, it's my own personal opinion. I think the imposition of this rule that you have to be hands-free, that may help, but it still is a distraction when you're on the phone. You're not concentrating on your driving. So I think you're still going to see those lawsuits, and I think it's going to be still a significant factor in establishing liability against the defendant that's operating a vehicle under those circumstances.
I saw one statistic that said distracted driving, 20% of accidents it's caused by. And of course, I think the texting and the phone and all that, it's the new drunk driving. I mean, when they talked about the last 2 years, more accidents and so forth, I mean, a lot of that is, somebody driving around like this, talking to their
Well, let me
friend
ask you
and,
this, Bob. In cases that you're handling now where you suspect that there may have been use of a cell phone at the time of the accident, I mean, the first thing you do is you ask for the cell phone records.
Right.
Correct?
Yes.
Just so you can establish that.
I read a study that says that a cell phone user is actually more dangerous behind the wheel than a driver who's been drinking.
Yeah, I think that's true, and it's by a factor of 3 maybe.
Yeah, and you actually managed a case successfully where you were able to show that the driver of the car near a school zone was on her cell phone at the time of the collision, right?
Yeah, and this leads to a topic Bob wanted to talk about. Does that have an effect on the damages you can get for the injured person?
Yeah, I think now with these 2 statutes, the one on texting and so forth, and now the phone thing, it really kind of opens the door to potential punitive damages in an egregious case, where somebody isn't paying a lot of attention and they're texting now, and it's not only illegal to text, it's illegal to even pick up your phone and talk on the phone with your hand.
Right.
And I think it may open the door to punitive damages.
Well, even if it doesn't open the door to punitive damages, it's going to have, I think it's going to affect the jury when they calculate the general damages, and they're going to be
right.
Yeah.
Punitive damages aren't covered by insurance, so you don't see a lot of cases where people plead punitive damages in an ordinary case. I mean, unless you get a zillionaire defendant, that comes out sometimes in a products liability claim or something like that. We've got a big, large corporate defendant. Now, if you had somebody for a big trucking firm and they're driving around, texting with their semi-tractor trailer, well, then there's your punitive damage case right there.
Yeah, but generally, there's impacts on the case from punitive damages that may or may not be obvious. But as Mike pointed out, the more egregious the misconduct of the at-fault driver, the more likely it is the damage calculation will be higher.
And not the punitive, just the general damages.
Yes.
Yes,
Right.
exactly.
Right.
Yep.
So a lot of times, you know, you're not even pleading punitive damages because there's no insurance coverage for it. But, you know, the jury gets the idea that this is really bad conduct, so the regular damages tend to go up with that, even though in theory they're not supposed to.
Well, and you know, we all know that despite what, you know, you might see on TV, punitive damages are extremely rare in Minnesota.
Right.
I mean, you don't ask for them because you're never going to get them anyway, right? Although I referred a case to a lawyer in California who sued it out.
Yeah, I knew you were going to talk about it.
He sent me a copy of the complaint and he asked for punitive damages. And I called him. I said, "Why would you do that?" And he said, "Well, we do it in every case." Well, that's California, I guess.
Well, there's one last thing on punitive damages, Mike. If you're defending a case and punitive damages are alleged, do you have to be a little more careful to worry about exposing the insured, you know, because the insurance is not going to cover it?
Yes, absolutely. But the other thing, though, is that the standard, you know, in order to establish punitive damages in the first instance, you can't plead it in your original complaint. You have to bring a motion to the court, and you have to establish that the defendant has acted with deliberate disregard of, you know, the safety or whatever of the plaintiff, and that's a high standard, and it's very strictly enforced in Minnesota. So you really don't see, I mean, at least I haven't seen very many punitive damages cases in my career.
Well, they have the drunk driving one, that if the person's drunk driving, there's a statute that allows punitive damages. And I even had a judge deny me punitive damages when it was a drunk driving case.
Yeah, that's very common for the judge to deny a motion to amend for punitive damages in a drunk driving case. They don't like them.
And even though the statute says they're supposed to.
Yeah.
Yeah. So you lost that too?
Yeah, I've also
And you?
won one.
Yeah.
Well, we're really good, aren't we?
Well,
Yeah.
I had a young associate from the firm handle the motion, so I'm not taking the hit on that. We have a couple of questions from callers. I don't know whose turn it is. Mike, I'll direct this to you. I had a back issue before an accident, but then the accident happened and it got worse. How does that affect the claim or the case?
Well, you're entitled to damages for the increase in symptoms and so forth. The fact that you had a prior back condition, that's actually something that we see quite commonly, you know, both from the plaintiffs and the defense side. People, you know, as they get older, things happen, and then they get into an accident and they get worse. So you are entitled to damages. And what's going to happen in a case like that, if it gets tried, of course, the defense is going to say, well, all of the problems are related to the pre-existing condition. And the plaintiff is going to argue, no, they're much worse. And it depends a lot on the medical testimony. You'd have testimony of doctors who would, you know, the treating physician for the plaintiff would presumably be able to testify as to the prior condition and then the extent to which the plaintiff's symptoms and conditions were increased. And you are entitled to damages for the increase in symptoms and the increase, you know, disability that you may have sustained because of that accident.
About 80–90% of American adults have gone through some kind of spinal problem for a period in their life, not necessarily long term.
Right.
So in almost every case, you can unearth something somewhere that somebody went to the chiropractor for 10 visits or complained to the family doctor or went to physical therapy for 5 minutes. And of course, that gets exploded into a lifetime of hell by the defense, right?
Go ahead.
Another caller with a question.
Yeah.
How does age of the injured person, I assume, affect claims from, say, a car accident?
Well, theoretically, the older the plaintiff, the fewer damages he's entitled to collect because he'll live with the pain for a shorter period of time. But that's not a hard and fast rule. Depending on the extent of the pain, how it's handled, you can actually get increased damages for an older plaintiff versus a younger plaintiff. So, older plaintiffs are difficult to represent effectively, but it can be done. And younger plaintiffs, theoretically are going to get more money, but that's not always true. It's not hard and fast.
Well, and most of our clients tend to be older because you're not so indestructible as when you're 20.
Right.
I mean, that's just the reality of the game, I guess, huh?
Yeah, 21-year-olds made out of rubber.
One quick question for you, because I know you wanted to answer this. How do you prove the speed of a vehicle when you're investigating a crash?
You do it with the airbag event data recorder. Every car that has an airbag is equipped with an event data recorder that records the speed immediately prior to the impact. And if you can get to the car before the insurance company junks it, you can download that data using a skilled crash reconstructionist and prove the speed of the other driver. And then no matter what they say their speed was, the event data recorder does not lie. It's like a black box on an airplane.
Well, and there are black boxes, but my understanding is it depends a little bit on the angles and everything.
It can.
I'm told we're out of time. That was a really good talk, though. Thank you very much, gentlemen. That's all the time we have for tonight's Lawyers on the Line. Thank you again to our guests. Thanks again to all the viewers who called in with questions. I'm Jim Peterson. Thank you. Good night.